It's Saturday, so you know what that means. It means we're going to be doing a recap on an abbreviated week of the Derek Chauvin trial. I was going to call it the George Floyd trial, that's what everybody knows it as anyways, but yeah, it's actually a really abbreviated week because we aren't going to bother with the Monday because it was just kind of the state doing some house cleaning stuff. There were a few witnesses called, but among them was George Floyd's brother, who wasn't even there, and said that George used to make them really great peanut butter and banana sandwiches. Like, what the fuck does that add to anything? And it was just a complete and utter waste of time. But no, they handed everything off, and then we pick up on Tuesday, and everything was wrapped by Thursday, like early afternoon Thursday, because the defense, well, they just looked across the aisle. They seen that the prosecution was continuing to bring up the exact same people over and over again, providing the same kind of testimony, the same appeal to emotion over and over and over again. And all of them were performing exceedingly well for the defense, so they just figured, hey, fuck it, we got a couple of people we can bring up here, strengthen our case a little bit, and we'll see how the dice falls, because closing arguments are supposed to be on Monday. And the jury will go into deliberation for probably a couple of days. I don't know. We should probably have some kind of a ruling by the end of the week, which is going to be fucking incredible. Because what I've seen so far, and I can't really corroborate this at the moment, but they've been closing schools in Minneapolis for Wednesday through Friday. I've seen some Thursday through Friday as well, because they aren't anticipating people to be happy. And I can see why. It's because the prosecution has really just kind of kicked the can down the road. It's like that overly confident high school athlete who goes to college, used to just absolutely run shop at the high school level, but just goes up to that next level and then gets the shit kicked out of them for the first month. And that's what happened here. They thought that they had this entire team of top tier prosecutors. They could come up there and present an ironclad case. They wouldn't have to worry about anything. I mean, look at that defense lawyer. He looks like a fucking IT guy who walked off the street. It's like, does he even have a law degree? But he ended up kicking your guys' ass. So I don't know. We're going to take a look from Tuesday forward. And actually, you know what? That's not fair. I do know. This dude right here, he was good. He was all right. But the big important witnesses came the next day. But we also got to take a look at this guy as well, because he was kind of important. Dude is Barry Broad, and we're using the same resource I used for the past couple of weeks as well, because, hey, they're probably doing the best job of this so far. So Barry Broad, use of force expert, and that's not because he did a great job on the witness stand for the defense. He's just getting the most coverage because there was another, I think 2 or 3 other people. There's somebody else we need to touch on in here as well. But before we get to that, Broad's performance fell astonishingly short of what the defense needed in this case, particularly on the specific context of use of force expertise. So he was kind of like the defense's version of the use of force expert that came from the LAPD, who, if you guys remember, was paid 5 digits in order to produce a 200-page document, but he only ended up producing 10% of the document, and he was also the same guy who watched videos on a PDF file. Yeah, kind of embarrassing. So long and short of it, yeah, Barry Broad, he was the lead witness for the defense. He came out and kind of stumbled a little bit. We're going to skip ahead to when Eric Nelson, the defense lawyer, he was doing his direct questioning. So Nelson's direct questioning would have appeared to be going well on the surface, as Broad provided testimony favorable to the defense on point after point. At least it would appear to be going well if one didn't know the likely points of attack that would be made the prosecution on cross-examination. If one did not know those likely points of attack, it was pretty obvious, even on direct, that they were not being sufficiently armored against attack. And just as the state's expert witnesses had done for the states, Nelson's use of force expert witness said the magic words on the defense required of him. In effect, that Derek Chauvin was acting with objective reasonableness. Nice weasel word conglomeration there. Following MPD's and current national standard of law enforcement, and in his interactions with Floyd, Nelson also had Broad touch upon a number of truly important points in the necessary narrative of justified use of force. For example, it's not the severity of the initial call that controls how much force to be used, but how severe the interaction becomes over the entire duration. A call for a minor offense could become a deadly force confrontation. Further, how much force a reasonable officer was obliged to use was, at the end of the day, a decision made by the suspect, whether they complied or resisted, and if they resisted, to what intensity. Exactly. Hence the reason why, Dante Wright got shot, because he resisted arrest. And what's his name in Chicago? I already forgot, because that one just fucking went out of the headlines like nobody's business, and that was only from a couple days ago. If he wouldn't have ran from the police, he would still be living his little homicide second life. That's one of his many nicknames in the community. When all the murals are going up, that's what's being put underneath of them. So no love lost there. Anyways, Nelson also had Broad make clear that the force involved in determining the reasonableness of the use of force included not just the 3 factors bulleted by the MPD manual: severity of the crime, threat of the suspect, resistance, flight of the suspect, but the entire totality of the circumstances and knowledge possessed by the officer. Yeah, so a police officer has many options available to them whenever they're faced with a suspect or a confrontation of sorts, right? Do they immediately go for their gun? If you're a small, retarded Brooklyn Center police officer, perhaps you do. But if you're a capable man, and Derek Chauvin, once again, he's one of these little manlets who clocked in at 165 pounds with his gear on and 5'8". To be fair, he didn't initially go for his gun, never ended up pulling it, but he had different holds, different restraints that he went to, of course. And that all is important to how the situation developed. So he asked Broad about different circumstances like positional asphyxia, which could not be possible for Floyd because nothing would have been pinched off by any of the actions that Chauvin took. The severity of the crowd and what they would have had to influence their decision to use the different restraints on him. And as we're going to see with a witness on this day as well, after we pass past Broad, that the crowd was a significant factor in what Chauvin and the other officers were doing. Importantly, Broad testified that in his view, the videos Floyd's arrest could have clearly seen Chauvin's attention being distracted away from the suspect and towards a growing and increasingly hostile crowd. So did they contribute into Floyd being shipped off to that giant fentanyl factory in the sky? Perhaps. There's at least enough reasonable doubt there for a juror with an open mind to make that decision, so we'll see how it plays out. So far, so good. Then, however, Nelson's direct questioning of Broad opened a huge target of attack for the prosecution when Broad testified that he didn't consider prone restraint to be a form of use of force at all. That's just as stupid as when Dr. Tobin, right, the kindly-looking gentleman who, this first time that he's ever been up on the stand, first time, he'd normally charge $500 for whatever speaking fee he would do, but he just felt so strongly about this case that he was going to waive his fee, and he was just going to go up there and he'd break his silence, even though he authored all of those books. He definitely wasn't being an activist whatsoever. And why am I categorizing him like this? Well, because remember the defense, it's like, oh, this guy wrote the book on pulmonology. He knows everything about lungs. And then he made some stupid comment like 90% of people who smoke don't have any adverse health effect. And that's what he said. And then you have a use of force expert saying holding somebody down on concrete is not a use of force. Fucking oof. How could you possibly take somebody seriously when they say that? Okay? Listen. I've said that the defense has done a remarkably good job. And I also gave the prosecution credit for the final 2 days last week that they brought up some experts who sounded really good. And if you were only paying attention to what either the mainstream media or whatever kind of coverage you were getting from them, you would have received that exact same information. But there were also some things in there as well that undermined the validity of their testimony. And that right there is exactly the reason why. So he was very much taken apart on cross-examination. So Schlechter was the one who was up there given the cross, the guy who looked really disheveled after, what was that, Tuesday or Wednesday last week? So yeah, he immediately went after Broad's view that prone restraint was not a form of force at all. What a dumb thing to say. Oh my fucking... All of these witnesses are just various levels of retarded. So Floyd in handcuffs, prone, on a hard street, well, asphalt, yeah. That was not a use of force at all, correct? Answered Broad. Not even if the enforced position caused Floyd pain. The position doesn't cause pain. Not even with a cop on your back and neck. Not even given the abrasion on Floyd's face and shoulder from the street. But no bruising and no other further cuts. Interesting. But yeah, he was going to die with that narrative. So yeah, you immediately go with that. I don't care who's listening to that testimony. And then it went on. That line of questioning went on for quite a while. Kept asking him different things, but that immediately poisons the well. Everybody could see that was some kind of a restraint. That was clearly, I don't know how you can not say that wasn't a use of force, but that was, yeah. That probably discredited anything that he had to say. And kudos to the prosecution for following up on that. Like, that's how you should attack. I guess they aren't totally incompetent after all. So moving along, Peter Chang, a parks officer, okay? Chang was on duty in a nearby park when he heard the radio chatter about Floyd's arrest, including that police were taking someone out of a vehicle believed he heard a struggle over the radio, and self-assigned himself as backup to the scene. Okay. We got fucking Dudley Do-Right on the case. Terrific. Chang had remarkably favorable testimony for the defense, perhaps most importantly that he perceived the growing and angry crowd as a prospective threat to the officers on scene. Indeed, he described the crowd as very aggressive to the officers, and you can tell that in the footage. He also provided body cam footage that once again reinforced that the crowd was angry. They were yelling, they were getting rambunctious, they were closing in, that they definitely played a factor in the assessment of the situation. About the video footage that Chang had, that almost sounds like a slur. So as described here, first, the manner in which the footage of the camera continually panned left and right over the scene from where he was tasked with controlling Hill and Hall by Floyd's SUV. Two other people that were in the hall, the drug dealer and another one of Floyd's ex-girlfriends, the other person who was also in the vehicle. She was in the back seat. To across the street where the officers struggled with Floyd. He was doing the smuggling. And then endured the insults and threats of the hostile crowd. That physical conduct strongly reinforced his stated perception of the crowd as aggressive. The commentary of Hill, Hall, and McMillan was particularly helpful to the defense. Hill can be heard exclaiming aloud, "Man, Floyd, still won't get in the car. Just get in, George." And what is he doing? Now he's going to go to jail after he continued to struggle. This is Floyd, of course. Maurice Hall can be heard muttering about Floyd. He's over there fighting with the law and shit. Very eloquently put. McMillan is overheard telling Hill and Haw, "I saw everything. Floyd fucked up. He fucked up. I tried to get him into the car, told him he can't win." Yeah, and like it's summarized here. It was pretty good stuff for the defense. Yeah, no doubt. No freaking doubt, dude. And then the Hill that was previously mentioned in the body cam footage from Chang is Shawanda Hill, the female passenger in Floyd's SUV, and also described as his ex-girlfriend. But man, Mama's going to feel really bad about this. Appeared in the body cam footage of Officer Chang. She also appeared in court to testify in person. And remember, she was called as a witness of the defense. So, not going to be good, okay? So, of everybody that was in that Mercedes-Benz, okay, you had Floyd, you had his drug dealer who pleaded the fifth, who never ended up testifying, and then you have Shawanda Hill being called by the defense. Oh my Christ. Most important part of her testimony for the defense was describing how Floyd was initially pretty regular in demeanor when he attempted to pass a bad bill in the cup food store, but then shortly after returning the Mercedes SUV, he suddenly fell asleep. Indeed, he fell into such a deep sleep that he could not be aroused. Not that way. Or when roused, he immediately fell asleep again. It was bad enough that she gave him the idea of getting a ride home for Floyd and called her daughter to come pick her up. Yeah, because she wasn't going to be a part of this fucking nonsense. But what does that mean? Well, clearly he was on something, okay? Something that was a little bit time released, right? That would coincide with the claim that Floyd was fucked up, okay? I think everybody could see that. Everybody knows that at this point. The toxicology reports cannot be falsified, but the state fucking is definitely going to try to dissuade your opinion on that. Remember, oh yeah, they pull over people all the time with way more fentanyl in their system than that, and they're still alive. Sure. But it looks like the fentanyl, or at least the fentanyl part of the methamphetamine goofball, speedball. I don't know. I don't do drugs. I don't fucking know this kind of shit. That was the part that was taking precedent first. Because another theory that's out there is Dante Hall was getting Floyd to get Hall cigarettes, okay, using the fake $20 bill, and in return, he would be getting some pills from Dante Hall, the drug dealer. That's one of the theories that's out there. Sounds plausible, but then at the same time, we're never going to get any confirmation of that because, did I say Dante Hall? I meant Maurice Hall. Anyways, Maurice Hall pulled the fifth, and unless he gets charged with something after this case might fall through, not too sure yet. But we're never going to know because that conversation happened between somebody who's dead and somebody who's not going to talk. So this was all that happened on Tuesday. It was a big old day, and then it kind of gets a little bit lesser from there because Wednesday morning there was a motion for the judgment of acquittal. Okay? Why? Because there was a slew of new information that was dropped. Court to hear motion for judgment of acquittal this morning. So some background on this. When a prosecution rests its case in chief, there is a theoretical possibility that even if everything the state said was accepted as true by the jury, that rationale guilty verdict would still be impossible. One such scenario would have been when a charged crime has, say, 4 distinct elements, each and every one of which must be proven beyond a reasonable doubt, but the state completely forgot to present evidence on one of those required elements, meaning there is a literally zero evidence in court of that element. Well, the only purpose in the jury would be to be the fact finder to evaluate the evidence. If there is literally no evidence on the element of the charge, then there is nothing for the jury to consider. And in that case, there is no rational bias on which the jury could conclude that element of the charge was proven beyond a reasonable doubt. Also to be considered, if only for practical purposes, of course, is whether any judge presiding over the case would be willing to take the political consequences of having taken the decision from the jury and handing an acquittal to a person that much of the body politic in jurisdiction believes is a racist police officer. Yeah, so the movement for acquittal kind of fell flat, even though kind of proved beyond a reasonable doubt that there is significant reasonable doubt in this case. So it ended up continuing on. And another reason that this was brought up was because, as you can see there, over 5,000 discovery items dumped on the defense during trial. Another interesting mention in yesterday's housekeeping meeting with Judge Cahill came up in the context of the number of disclosures and exhibits that have been dumped on the defense in this case, a large chunk of which have been dumped on the defense even as the trial was taking place, which is a little bit sus if you ask me. As background, there is always materials collected by the parties that ought to be shared with the opposing counsel as part of discovery. Under Minnesota procedure, each item is labeled with what's called a Bates stamp, a unique identifying number and then a bunch of these are collected together and delivered as a disclosure. Ideally, by the time a trial actually starts, both sides will have long since received the other's disclosure items early enough to have time to consider and research them before trial begins. This is the exact same tactic that happened to Trump's defense team during the most recent round of impeachments. I don't know if we're going to be done yet with that, but as of right now, the most recent impeachment attempt, where during closing arguments, I forget which member of the impeachment managers, one of the ladies that was up there was trying to play a new video that was never presented before, and then she got scorned because of it, and what a disaster. But yeah, as you can see here, when the trial began, the state had already delivered the defense 41 disclosures consisting of 45,118 Bates stamped items. That's a ton. Since the start of the trial, in other words, while the sole defense attorney Nelson has been occupied the entirety of every day on this trial and case, the state has continued to deliver disclosures to the defense, each containing a great many Bates stamped items. Indeed, since the start of the trial, the state had made 12 additional disclosures in the defense, consisting of 5,154 additional Bates stamped item. Fucking Christ, dude. They just realize that they don't have too much of a case that's there, so they're just going to continue to pile on evidence and hope that Nelson's just going to end up drowning in all this kind of stuff. But he had a couple of bad days last week when Tobin was up on the stand and then on the preceding Friday, but he bounced back perfectly. So it's important to notice that if you couldn't tell from the previous videos and everything that we've done covering this trial up to this point, the prosecution has unlimited amount of money that they can pour into this, and they're using every shitty tactic in the book, and it's really not working. But again, we'll wrap this up in a minute, but Nelson's really earning everything that he's going to be getting from the outcome of this case because, like it or not, he has been surgical in his cross-examinations and his direct questioning, and especially this guy here, David Fowler, probably the best expert witness that the defense could have called. So yes, the defense had originally called, or planned to call, Maurice Hall, and then he pleaded the 5th on this day. This is Wednesday. But he sent his lawyer up there and was like, no, we aren't going to do anything. Don't bother trying to talk to us. That was also done without the jury being present, so they couldn't be swayed by that, theoretically. But at the same time, they were also having to contend with the Dante Wright shooting that was happening in Brooklyn Center, not but 20 miles from where this was actually taking place. So if you're telling me that those 12 jurors, the 2 alternates as well, were unaware of this situation, that they were being 100% perfectly sequestered, I've got a bridge in New York to sell you. What did Dr. Fowler have to say? So Dr. Fowler was prepared to say the magic words that the defense needed to say in the context of having formed an opinion to a reasonable degree of professional certainty as to the case and manner of George Floyd's death. George Floyd had a sudden cardiac arrhythmia due to atherosclerosis and hypertensive heart disease during his restraint by the police. So it wasn't Chauvin that killed him. It was a multitude of other factors, including an overdose, including having a bad heart, and as many other goofy factors as you could possibly think of. Contributory conditions that had led to the fatal outcome included Floyd's existing heart disease, yes, substantial coronary artery occlusion, and pathological hypertension resulting from an enlarged heart, fentanyl and methamphetamine toxicity, an existing paraganglioma, and another factor mentioned for the first time today, exposure to carbon monoxide from the exhaust of squad car 320. You just can't make this up. I thought it was a meme, but yeah, no, it's a real thing. Could the carbon monoxide from the squad car have killed him? I don't know. Makes sense. Maybe. Fowler's view, however, was that it was not a profound low oxygen state induced by the police via subdural restraint and positional asphyxia that caused Floyd's heart to stop, but rather it was Floyd's exceptionally fragile physiological condition. You remember, it wasn't that Tobin, right, star witness of the defense last week, saying that, yes, it was a very low amount of oxygen in Floyd's bloodstream that caused him to die, but there was nothing about choking or being restrained on there because the medical examiner said that there was no bruising. There was no constriction on the windpipe, no blood choke that was competently applied. So basically coincides with, a condition unknowable by the arresting officers that made his heart exceptionally vulnerable to even the modest shortfall of oxygen caused by Floyd's decision to fight arrest, resulting in cardiac arrest. Exactly. He goes on and continues to beat the same drum, and that's what the defense needed him to do, right? They needed somebody who comes up for them, somebody who has prepared testimony that, here's all the facts, I've assessed the facts. You know what? It wasn't a great thing that Chauvin had his knee on his back, neck, shoulder, what have you, depending on which body cam footage you're looking at. It was a multitude of all these things that added up to Floyd's death. So then that leads us to Thursday. Thursday. Everything was all wrapping up, and the defense tried to pull a fast one, and it almost resulted in a mistrial, as you can see here. Mistrial narrowly avoided closing arguments on Monday. This upcoming Monday. Brace yourselves. Anyways, we're just going to cover the top here because that's what's important. The almost mistrial. So the defense rests their position. They weren't going to call anybody else, but then the prosecution wanted, because there was new evidence that was presented. It's not like they haven't been dumping that on the defense. No. But there was new evidence. Was purportedly just discovered data on Floyd's blood oxygen levels when at the Hennepin County Medical Center. That doesn't make any fucking sense whatsoever. The state wished to have Dr. Tobin, of course they would, testify about the data to rebut suggestions by Dr. Fowler that given the proximity of Floyd's face to the exhaust of the squad car 320, it was possible that Floyd's carbon monoxide blood concentration could have been as high as 18%, a level Fowler testified was sufficient to be dangerous to Floyd and the contributing cause to Floyd's death, given Floyd's fragile physiology. As these things tend to go in court, the argument over whether to allow Tobin to be recalled as a witness for the rebuttal purpose took about twice as long as it did for the actual testimony, but for good reason. Obviously, this demand for rebuttal by the state, particularly on the blood data discovered just after Fowler's testimony ended yesterday afternoon, and with notice provided to the defense only about 5 o'clock in the evening, was about as late in the course of the trial as could be imagined. Further, the defense expert witness on the subject matter, Dr. Fowler, was presently on a plane flying home while the state was arguing in court for their own expert, Dr. Tobin, to be recalled. And then Judge Cahill fucking went off because he was not going to have any of this, okay? They had access to this stuff. It's not like they just reopened up George Floyd to figure out this stuff, okay? All of this stuff was written down. You guys were too stupid to fucking address this. And then the defense's star witness, their medical expert, comes up and says, yeah, it could have been a multitude of things. And, oh, yeah, right, we can see that he's in close proximity to the exhaust for the exhaust from the car. And all of a sudden, that's fucking revelatory. Weren't you guys supposed to look at all of the video evidence that was presented towards you? Shouldn't you been able to come to some sort of a reasonable conclusion based on that? Nah, fuck it. We'll just call in Dr. Tobin because he looked good for us that one day. Unbelievable. Judge Cahill agreed with the defense with this respect to the newly discovered blood gas level data and informed the state that if Tobin so much as hinted at this new data, the judge would order a mistrial had occurred. That said, Cahill said he would allow Tobin to speak to the CO concentration issue if only referenced the data that had long been available to both parties. That opened the door for the prosecution having Tobin reference Floyd's oxygen rather than carbon monoxide levels and use of O oxygen level to infer possible CO level. The state claimed that Fowler's reference to this PubMed search was new evidence not previously shared with them, again qualifying as ambush testimony. Oh, Christ, of course. You know, Big Daddy government's always the victim in this situation, and again providing the exception necessary to have Dr. Tobin testify on this issue of rebuttal. The state indicated that Tobin would testify that there were, in fact, a number of scientific papers and studies that supported his claim. Of course. So in the end, Tobin was permitted to speak on this issue of inferring a maximum CO concentration in Floyd's blood for no more than 2% on the measured O level of 98%, and to inform the jury that he was aware of some 12 to 20 scientific papers that supported the notion of a smaller lung volume resulting in a narrowing of hypopharynx. Okay, so he had a 98% oxygen level in his blood, and that the publicly available carbon monoxide levels in his blood is no more than 2%, and he couldn't be asked to narrow it down between 12 and 20 papers. Come on, you're fucking grasping at straws at this point. And that's why Cahill went fucking off. So yeah, that's a wrap. That is a wrap. So we're going to be back on Monday with the closing arguments, and that'll be interesting. That'll be very interesting. Because if you guys remember, Eric Nelson, the defense, they banged on the facts. They banged on the evidence that they had and said that they would prove a reasonable doubt that Chauvin, yeah, okay, he applied force to his back, but it didn't result in his death. Okay, there were a multitude of other factors that could have led to George Floyd dying that day, and there's reasonable doubt that he did, right? And then the prosecution on the other side, they had Prosecutor Blackwell up there saying, please, won't somebody please think of the children? No, it was just an appeal to emotion. They had a bunch of wonderful graphs. They had a bunch of wonderful eye-catching displays. And oh my goodness, it was tear-jerking because Chauvin was a bad man who had a knee on a neck or back for about 9-ish minutes, and you'd be able to find beyond a reasonable doubt that Chauvin was the sole reason that George Floyd bit it that day. So unless there is a colossal calamity that happens on Monday, man, I really don't know. Like, I look at all this stuff and I can clearly say that there is reasonable doubt and he wouldn't be guilty on any of these charges, right? The manslaughter charge, the murder charges, they just don't seem to fit, not in my opinion. But then you have those other jurors that are on there, the 9 that aren't quite as receptive to the facts, that were super excited to be on the jury, that one of them is already looking at getting a book deal. But we'll revisit this on Monday. It's the drop dead date. And all of those jurors right now, I'm pretty sure they're being sequestered, but they've got to know that they have a big decision in front of them. And if they bought the mainstream narrative line that, guess what, there will only be riots if he is acquitted, and they aren't going to look at the fact that riots are going to happen regardless. Oh, man, I don't know. But like I said, we're going to revisit this on Monday, see how everything wraps up, and then, like it says here, Cahill suggested that they plan for a long sequestration in hopes it turns out to be a short one, but that ultimately only the jury could decide how long deliberations would take. The jury was then dismissed. Yeah, we don't know until it happened. Like I said, I don't think that the evidence supports any charges, but at the same time, I'm not looking to get a book deal. I'm just looking at telling you guys the truth, or at least as best as I can tell it. I thank you all very much for the gift of your time. I've been Don Consuelo. I want you to follow your gut and get after it. Take care, everyone.